should I even bother having a will? I mean, most people think that, oh, well, my wife, the kids, they'll get everything anyway, don't they? So what would you say about that particular comment?
Well, I was interested to see the Count brochure on estate planning actually explains what a will is. So I guess we might start with that. Does everybody here understand what we mean when we talk about a will? Is anybody not sure about what a will is? Essentially, a will is a document that tells society and your loved ones, etc., how you want your assets dealt with after you pass away. Because of the importance of the document, that is, you're gone, so there's no one to be there's no one around to make sure that what you've said is correct. That when to have a will, you have to follow some fairly rigid technicalities, because our legal system demands that in order to enforce a will, it needs to make sure that the person who signed it was in fact did in fact sign it, and it was their intention to do so. So in this state in particular, you need two witnesses to a will. They have to be independent people and so on. So having established that as what a will is, why would you bother having a will? Well, if you die without a will, that's called intestacy. You are said to be intestate, as opposed to interstate, which means you're over in Victoria. But intestate means that you don't have a will. And intestacy is complex, much more complex when it comes to administering your estate. If you die without a will, somebody has to volunteer to look after your assets. And that could be anybody in your family, and it might even be more than one. So you might actually end up with some of your family members fighting over who will look after your assets. Someone who looks after your assets when you don't have a will is called an administrator. When you have a will, the person who looks after your assets is called your executor. And that executor is appointed by you by the will. So if you die without a will, you have to find somebody, somebody has to apply, has to volunteer to look after your assets, and that volunteer then has to be approved by the court. That volunteer is then appointed as the administrator and then administers your estate in a similar way as your executor would if they'd been appointed under the will. Now, when you say, do my wife and kids get everything? Essentially, yes. If you don't have a will, your spouse gets all of your personal effects plus the first $350,000 of your estate. The remainder of the estate is split 50-50 between your spouse and your kids. So if you want that to happen, and most people find that a sort of a rigid division of assets, then you could do without a will, but you're then in sort of no man's land. It's just messy, and actually applying to have a volunteer go up and apply to be the administrator involves a lot more paperwork. So we normally obviously suggest that people smarten their act up by having a document that everyone can rely on, everybody knows what's in it, you appoint your executor appropriately, and you can also deal with some of the other issues that flow on. The will, as I'll be saying on a number of occasions tonight, we don't talk about wills on their own much anymore, because wills are just part of what we talk about as estate planning. These days there are a whole raft of things that you need to consider, and that includes your superannuation, which is outside the will. You need to consider if you've got a testament, if you've got a family trust, how to deal with that, because that's outside the will. You need to work out the issues like who's going to look after your children if you and your spouse are not around, and so on. So there's a whole raft of things that need to be considered, and that whole raft of things is what we call estate planning. Looking after your family and your assets all within a package of documents that provide the same a total solution, if you like. But the other benefit, I guess, about having a will is that you can, through your will, you can help to protect your the inheritance of your beneficiaries, particularly, for example, your children. If you use a will and you use a vehicle that we call a testamentary trust, you can help to protect their inheritance from their debtors, from perhaps their estranged spouse, from if they've got a drug abuse problem or a mental health problem, or even if they're just bloody hopeless with money, you can help to support that through what we call a testamentary trust inside a will. And we'll probably talk about that a little bit further on. So there's a whole raft of reasons you have a will. Certainty is the main one, clarity is the second one, and being able to have a part of a good estate plan is the third one, possibly protecting the inheritance of your beneficiaries is the fourth.
Okay, that's a good, that's a broad description of will. So let's go through a few, I guess, direct little questions here. If I had a will done about 6 years ago, and this is before the birth of my last child, should I even bother getting it updated as there's been an addition to the family?
Yeah, well, because it depends what was in it and what you said in your previous will. But if you didn't mention your children in the previous will, then there is a risk, because if, for example, if there was only you and your spouse at the time, we'll talk about you, George, because it makes it nice and easy. If there was only you and your lovely wife at the time, and you didn't have any children, and you simply said in the will, I give everything to my lovely wife, what happens if something happens to the two of you at the same time? Husbands and wives tend to travel together in cars, much to the husband's annoyance sometimes, but and in planes and on trains and so on. So if something happened to the two of you at the same time, the will would effectively be pointless, because you haven't made any provision for anything else to happen. Now, Section 35 of the Succession Act in New South Wales says that a person has to survive by 35 days in order to, 30 days in order to inherit. So if you and your wife were unfortunately killed in the same car accident, neither of you has survived by 30 days, and effectively you would both be intestate. So your assets would then be dealt with in the manner that we talked about before. Your child has been born. We say to people that wills are, in the old days when everybody used to write out by hand wills, and seen all the English shows with the solicitor blowing dust off. Those solicitors must have suffered from shocking emphysema, because their offices were always full of dust. But blowing the dust off documents and writing long wills longhand with a quill, etc. In those days, you wrote out a will and you very rarely changed it. But these days, with word processing and what have you, wills can be amended very quickly. And we now normally tell people that they should review their will every couple of years. Most of the time there may not be any sort of issue, but things change so readily. Kids grow up, they get married, they get divorced, your own personal circumstances change, etc., etc. So reviewing your will every couple of years is a great idea in order to make sure that it's up to date. And that review can be simply just reading it through, just to make sure that you haven't missed anything.